Big hello, everyone. Welcome to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and I'm going to be your host for today for an hour or so. And before we start off, there's this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, today we are going to have a very important discussion on a topic that is on everyone's mind. What's happening with H1B adjudications in 2024? And joining us is an esteemed guest, none other than Attorney Chand Parvathaneni, managing attorney at the law firm of Sin Parvathaneni and Brown in Dallas, Texas. So, without further ado, please help me welcome him back to the show. How are you doing today, Chand?
Hello, Nipasa. Everything is looking pretty good, and thank you for inviting me over. We'll have a very good discussion today on this very important topic.
Absolutely, we will. And Chand, how's it going with you and your dailies out there in Dallas, Texas?
Luckily, our summer, I think, has come to an end. It's getting better, and then the H1B, the second lottery, the deadline is getting closer, and we're trying to wrap up our second lottery cases. And
Mhm.
things seem to be a little bit smoother with USCIS. USCIS seems to have become a lot more efficient lately. They have been using a lot of electronic systems. They have been trying to upgrade their systems, and
Yes.
things overall, at least on the USCIS side, seems to be a pretty quick, pretty streamlined compared to what it used to be a couple of years back.
Okay, okay. And I think with the recent shifts in this H1B process and trends, this discussion is more relevant than ever then. So I think without further ado, we should just dive right in and explore the latest updates, challenges, and even the changes that are going to be very meaningful in this discussion, both for employers and employees. So are you ready, Chand?
Yep. Yes, Nibasa. Yep.
I have a question regarding what's happening with this topic, H1B adjudications in 2024. What are the current trends in these H1B adjudication delays?
So in terms of the delays, I think in the last couple of years, I've never seen H1Bs processed as quickly as we are seeing in the last couple of months. There are still
Mhm.
delays, but overall, I think what we are seeing is things have become smooth. Things have become a lot more faster. And for the cases that we see delays, we do have some delays with some cases, and that is more than likely because some cases will always have increased scrutiny. They will have more requests for evidences, RFEs. So those cases that are getting RFEs, or sometimes some cases randomly get selected for an audit. Sometimes some companies will have more scrutiny. So we are seeing delays due to those reasons for few of the cases. And these RFEs, these random audits, site visits, they do contribute to delays in processing times, and
Mhm.
those do cause delays for a lot of cases. And when it comes to delays, some of the delays are also due to measures by USCIS to detect fraud, to prevent fraud. And what USCIS does is USCIS routinely does site visits. And sometimes site visits happen even before the petition gets approved. So you have an outstanding petition out there with the USCIS. Sometimes something triggers an audit or something triggers a site visit. And these cases, what happens is the officers are waiting for the site visit to finish to get the data back. And these few cases, sometimes we see increased delays, and it slows down the adjudication. So that's one of the reasons why some cases tend to have more delays. Overall, the timelines. We have seen cases in regular processing get approved in less than a week. So not every case will have the same timeline, but routinely we do see cases getting approved very quickly, less than a week. And if you're looking at like an average timeline, one main thing to remember is for the H1B adjudications, the petitions go to different service centers. We have multiple service centers. We have California Service Center, Nebraska Service Center, Vermont Service Center, and Texas Service Center doing the H1B adjudications. And what that means is, depending on the office where your H1B filing is at, the timelines could be a little bit different. So sometimes we see one service center doing things very quickly, another service center doing things slowly because the staffing levels are not the same, and the case levels are not the same at every service center. So we do see like an average timeline between a month to 3 months. That is pretty much what we are lately seeing. A month to 3 months is what we are seeing for most of our cases. Many of the cases that we filed during April, May, June, the H1B lottery cases, we have seen a number of approvals, hundreds of approvals so far. And we also have seen many cases where they're still in process, even after 3 months. And what that means is 1 to 3 months is what more than likely you can expect to see some kind of adjudication, maybe an approval, maybe an RFE. And the cases that are typically taking more than 3 months, there is probably a reason. Maybe they're doing some kind of an audit. Maybe the staffing levels at that particular service center are not enough to do things quickly. So it could be due to various reasons. And what that means is some cases always will take a long time, but not every case takes a long time. And average timelines, I would say 1 to 3 months is what everybody should expect. That being said, we do have premium processing. So for those one-off cases where you require premium processing because there is some reason, maybe your cap gap employment authorization is ending very soon, you don't have a choice, you need to have an approval to continue to work. So those one-off cases, we do have premium processing. And by doing in premium processing, you can guarantee an adjudication, whether an RFE or an approval, in 15 days, in 15 business days. And so I want to conclude by saying that the timelines are actually very good right now compared to the last couple of years. Things definitely look a lot more streamlined on the H1B adjudication side. And the main reason is USCIS upgrading their systems, using a lot of electronic upgrades this year. We have e-filing. All these things, I think, are showing an effect. They have greatly reduced the timelines. Hopefully, this is good news for everybody who's got a pending H1B. I do expect to continue to see H1Bs getting adjudicated in a faster and a more efficient manner as USCIS uses more and more high-tech IT systems to help in their process.
Absolutely, Chand. Very well said. And yes, we did see some upgrades and updates in systems and processes this year. So definitely, it has helped reduce the timeline. So what else, Chand? Thank you so much. Thank you for taking that question and for the detailed explanation. I have another question. If you can tell us, how are delayed receipt notices affecting H1B processing in 2024?
Sure. In 2024, we did see delay in H1B receipts multiple times, and there is a big reason for that. The main reason is in April 2024, USCIS completely changed their process. And what they have done is previously, USCIS has multiple service centers, and for H1B filings, the files are processed by multiple service centers, and they used to have a formula. If a company is located at a certain location, the file has to go to a certain service center. So you cannot really game the system. There is a particular formula that you have to use. So for example, if a company is situated in, say, for example, Florida, it had to go to Vermont service center previously. So they had these rules. And then come April, what they have done is they've changed their process. They've changed their intake process. And in the new process, the H1B filings have to be sent to a logbox. Again, they got a formula. So depending on where the company is located at, it has to go to different logboxes. So there are multiple addresses that that receive the H1B filings, and this is based on where the company is located. Okay. And what happened in April is that because of this change in process, instead of sending it to the service center, now we have to send it to a USCIS logbox. Yeah. This change in process, I think initially what it caused is it delayed the receipts. Receipts were delayed because it's a new process. Files were going to logbox, and the staffing levels were not proper in the initial days. It did take almost 2 to 4 weeks, in some cases even a month, for us to get receipts. And normally it takes about a week. So normal times, you send the case out to USCIS, in about a week you get the receipt back. So there were delays. People were concerned because there are deadlines and people need to see the receipts to start working. sometimes during H-1B transfer, you need to have the receipt to start working. Sometimes their status expires, and they want to make sure they have a receipt notice to confirm that they are allowed to stay back in the country. And whenever the receipt notices are delayed, there is always a concern. But luckily, in the last 2-3 months, things look very streamlined again. Looks like the lock boxes are well set. Nowadays, we are not seeing delays in receipt notices. In normal timeframes is we send a H1B petition to this logbox. Logbox typically in 1 or 2 days they finish receipting the case. They send the receipt notice via mail, regular USPS mail. In about 7 to 10 days, we should receive the notice with the receipt number back. That is what has been happening lately. And also another positive change that happened this year, starting from April 1st, is we do have e-filing. So nowadays we have an option. We can paper file or we can e-file. So any of those cases where we have an urgency for a receipt notice, maybe because somebody's status is expiring, or maybe there is an H1B transfer, they want to see the transfer notice, transfer receipt before starting employment. So now we can do an e-filing and we can get the receipt the same day, instantaneously. So this is a new thing that has started in 2024 April, and now because of this e-filing system, we can get the receipt the same day. So this is
Oh,
very beneficial improvement that has happened this year. And the e-filing website, it is still not very stable. We are still seeing a lot of issues. That being said, at least the urgent cases where you need to have the receipt very quickly, we can utilize the e-filing website. And overall, luckily, at least in the last couple of months, getting the receipts has been very smooth.
that is wonderful news. But Chand, like you said, 7 to 10 days. So from the 11th day, that means will you consider that the receipt notice has been delayed?
Anytime it takes more than, I think, 7 to 10 days, I would say it is delayed. And most of the time, there probably could be a reason. For
Okay.
example, if something is wrong in the H1B petition, maybe USCIS is about to send the package back. So anytime it crosses 10 days, I get concerned. Maybe something is wrong with the H1B petition. Maybe something is wrong with the fee. Maybe something is wrong with the check, and so on. Or maybe the file got sent to the wrong lockbox, etc. So anytime it crosses 10 days, it is always a concern. And at that point of time, what we do is we ask the petitioner, because they write the checks most of the time, we ask them to check their bank account. And if we write the check, we check the bank account. If you at least see the check being deducted in the bank account, at least that gives us some kind of a cushion, and that tells us that everything is okay. Maybe something is getting delayed in mail or something. But if the check is also not deducted in about 10 days, I would say, at least based on the current timelines, it is probably a reason for concern. Once in a while it does happen, but it is not a general thing that happens. You should at least see the check being deducted in about 10 days.
Scenario. Okay, Chand. Thank you so much for taking that up and for the detailed explanation. I have another question now, Chand. If you can tell us, has the USCIS ELIS system migration impacted H1B adjudication times?
Sure. So the USCIS migration to ELIS, which is basically their electronic immigration system, it definitely had a noticeable impact on H1B adjudication times. And the impact is, I would say, both positive and also negative. So we have seen the good things happen. We have also seen the negative things happen. And talking about the positive side, so ELIS was designed to modernize and streamline the immigration process, the filing process. And what they've done is they have let us digitally submit petitions or applications. They have let us pay online, and we can track cases online in the portal. And we're relying less on FedExing, paper-based filings, where things could go wrong, because paper-based systems are definitely not efficient in this modern days. And the positive thing is it definitely led to more efficient, more streamlined way, more visibility. So you can file the case, you have very good visibility. You file the case, you get the receipt the same day. When you do a paper filing, you're sending it via FedEx. And sometimes you don't know if the file is lost in FedEx, because sometimes files get lost in FedEx. Sometimes files get lost at USCIS. We have had number of cases where the FedEx said the case is delivered, and the case was lost at USCIS. It does happen. Not a whole lot, but sometimes it does happen. Now, with this ELIS system, we have a very good visibility. The file reaches USCIS, it is visible on the portal. We get a receipt on the portal the same day. So the visibility is what is a major change. and it really helps mitigate any delays, maybe administrative error, maybe missing paperwork, maybe missing FedEx. So all these things have been solved in one stroke through this e-filing system. And however, the problem, the negative side, what we are seeing is USCIS has just started, for example, on the H1B side, we have just started this e-filings from April 1st. And the system, the website, it is plagued by pretty significant challenges. We have seen the website being extremely slow at times. We have seen the website being down at times. We have seen things not working like they should, because it is still a new system. And not only that, not many forms are still available on the My USCIS portal. We can do H1s, but if you have a H1B plus H4, for example, or a H1 plus H4 and EAD, for example, we can do a paper filing, a concurrent filing simultaneously. On the e-filing system, we still have a challenge. We cannot mix up H1B filing with the dependent spouse's H4 filing. And what that means is we still have a large number of USCIS forms that we are still waiting to get e-filing capability. And this definitely has caused some delays, because so right now USCIS has two processes. We have an electronic process, we have a manual process for H1Bs. So this, I think, is still kind of causing some inefficiency. And the way things are done for the paper filing is a lot different from the way things are done for e-filing. And this, I think, is still causing some delays that can be avoided. But again, it's a new system. It just started in April 2024. I think these significant challenges will still have to be overcome. We had a number of issues last week. The system was not working like it should last week. We had a number of attorneys tell us that things were not working. We had issues. We actually have some outstanding tickets with USCIS right now. We are working on some errors that we're getting right now on the e-filing website for H1B filings. So we were not able to e-file in the last 3-4 days. And we submitted what we are seeing to USCIS. We're waiting for a response. So these kind of challenges are what we are still seeing. The reason being, it's a new system. But in terms of timelines, I think we are seeing this e-filing system being of great help. E-filing is definitely, I think, a great step towards the future. But it just started in April, so we expect to see some challenges for some time. And this ongoing transition has definitely introduced some inefficiencies, but overall, I think it's a positive change. It's going to help the H1B system a lot in the next coming months, coming years, for sure.
Absolutely, Chand. Then we are looking forward for more upgrades in the website so that it runs more smoothly, and maybe we'll not have these breakdowns or breaks in between where it doesn't work. You know, so looking forward for that too. And thank you, Chand, for the detailed explanation. I have another question, Chand. If you can tell us now, what role does USCIS exemplar status play in the H1B adjudications?
So typically, when we talk about USCIS exemplar status, it is mainly concerned with
Exemplar.
other visa categories, not really H1B. It is typically used for EB5 investor program. So exemplar approval is basically an approval given by USCIS, and what it means is it is given for a project. And once the exemplar approval is given, it will help the next few petitions. It will help in the speedy approval of the next set of petitions. So it is more for a project for EB5 category, not really for H1B. But the closest equivalent we can think about from a H1B perspective is when you have previously approved cases, or when you have successful case precedent. USCIS, for example, the employer has a number of similar H1B petitions, same job, same salary, etc., and they have been approved by USCIS. The subsequent petitions, they typically experience smoother adjudication. USCIS does not have to give value to those previous approvals, but normally what we say is if USCIS has already approved similar petitions for the employer in the past, it is a lot easier for USCIS to be convinced about employers' bona fides and compliance with prior filings. So typically, we might see speedy approvals if USCIS has approved such similar cases in the past for that same company. But they don't really have to follow it. Unlike USCIS exemplar status that is given to a EB5 project, on the H1B side, it is not the same. They have a discretion. And what that means is, yes, they do look at the past and the precedent set in the past approvals, but by law, they're not supposed to use that and say they have to approve the case. However, in USCIS, when it comes to applying for extensions of an employee, and that employee got an approval in the past for that same job. The current trend is USCIS typically will approve that case if there is no material change, and they will give some value to that previous approval. So that does happen when that same employee for that same job is having an extension being filed by that employer. So we do see that during extensions being filed for that same employee. If everything stays the same, USCIS does give value to the previous approval and typically tries to approve that case.
Okay, that's very interesting. And even if they're looking for something new, they would look for some advancements better than before, right?
That is true. So what they're trying to typically see is if there are some material changes with the previous approvals, they always will have different kind of
Mhm.
scrutiny. But if things are the same and they've already approved for that same employee in the past,
Okay.
that employee has met the standards of beneficiary qualifications, that position has met the standards of specialty occupation, and if everything is same as the last approval, they want to make things easier. So they typically make sure the company is complying with H1B, which means they'll look at the pay statements, make sure they're paying that person as required. They'll make sure the person is working as required at that particular location. But things like specialty occupation, beneficiary qualifications, they don't have to be re-adjudicated because there is no material change. So whenever there is no material change, it is a lot easier for a USCIS officer to be convinced and approve such H1B extension cases.
That's very interesting, Chan. Thank you so much for the detailed explanation. Well, now I have another question, Chan. Then, if you could also tell us now, what factors lead to longer processing times for H1B extensions or amendments?
Sure. So in spite of USCIS being very efficient in the last 1 year, or definitely in the last 6 months, where things are moving very quickly, people are getting a speedy adjudication of their H1B petition. We still see some cases take a long time, and there are several factors that contribute to longer processing time for either a H1B extension or an amendment. And the reason for such for lengthier adjudication is USCIS has heightened their scrutiny of H1B applications, the H1B petitions. And what that means is they do a lot of scrutiny. They have very, very good computer systems that can detect fraud, that can gather information from various sources and tell them if things are looking right. They also do a lot of site visits. So they have a very good process where they use this FDNS process, site visits, where they kind of make sure the petitioners are complying with the law. And sometimes what we see is if some some detrimental information is found about a company, maybe from a site visit, maybe from something else like a consulate visa appointment, maybe they got some detrimental information, or maybe it's just a random audit. In those cases, what happens is USCIS tends to do more scrutiny, and sometimes they issue a request for evidence. They're not satisfied even if everything looks good on the face of the petition, because they have something in their system, something in their background analysis uh, that warrants heightened scrutiny. They issue an RFE, and anytime a request for evidence is issued, it will delay the process, because now a request for evidence will talk about all the things that they're not satisfied, and it will provide them 90 days of time. So now the petitioner is also required to look at the RFE, look at all the documents that are listed, and provide a good explanation, provide the documents. And providing these documents take time. And USCIS understands that. They give almost close to 90 days. So people have 90 days to get their response ready and file it with USCIS. And what that also means is, depending on the kind of RFE, depending on the kind of response that was given, depending on the volume of the response, USCIS needs some time to go through the petition. So sometimes, even if it's an extension, even if it's an amendment for a person that is already working for that petitioner, we sometimes do see increased timelines. and could unfortunately delay the process. And then sometimes nothing to do with background checks. Sometimes it is just the workload at the USCIS service center. Maybe the officer that has this file has a lot of workload. Maybe he went on leave. Maybe that service center has a lot of cases compared to these other service centers which are doing things very quickly. This also sometimes causes a lengthier processing time, which could happen time to time. And sometimes technological issues and system transitions. USCIS has a new system this year. They have e-filing system. They are modernizing their systems. They are going towards the e-filing route. And during this process, sometimes some cases get stuck because of these changes, because now USCIS has a paper filing and also has an e-filing. So these kind of system transitions, system upgrades also tend to slow down some cases, not all cases. But if your case is one of those cases that got stuck in this transition, maybe you're seeing a, a lengthier processing time for your case. So overall, what we suggest is try to have a filing that is as accurate, as thorough as possible, and file it as soon as possible. Because when you have H&D extension being filed, you don't really have to wait until the last minute. You can file 6 months before somebody's status expires. So we tell people to apply as quickly as possible and as thoroughly as possible. And then all you can do is take a look at USCIS website, make sure you're tracking your case, make sure everything looks good. Keep track of the processing times. The processing times for every service center, it is available on the USCIS website. And the service centers tend to have different kind of timelines. So do keep an eye and see what the service center where your case is doing. That will at least give you an estimate. Maybe maybe sometimes you are beyond their timelines. Sometimes maybe you're within their timelines. And in those cases where you fall beyond their timelines, so they gave you a timeline on their website, and if it is taking longer than that, the best course of action is to open a service ticket, create a service ticket with USCIS. It's a very easy process. If you have an attorney, you can talk to them, and they should be able to initiate a service request with the USCIS service center. And sometimes the service ticket will give USCIS an opportunity. And what we typically see is in 30 days, they come back and either say, yes, there is some reason we are taking some time, or if there is no issue, they will try to process the case. So opening up a service request is one good way for those cases that are taking longer than the published timelines.
So it's always best to, submit it thoroughly and a little early so that you have some time in hand. And that is the best way to do it, I think, Chand, right?
That is right, because I think at least with things that are in our hands, making sure the petition is thorough, making sure the job duties are pretty detailed, you apply as early as possible, practically possible. So at least these are the things that are on the hands of the petitioner. So at least by doing so, at least you minimize any predictable issues.
Absolutely. Thank you, Chand, for the detailed explanation once again. It's very nice and clear how you explain it. So I have another question now, a few more questions actually. So I'll move on to the next one quickly. And if you can tell us this time, how has the H-1B adjudication process changed in 2024 compared to previous years?
Sure. So a couple of years back, we used to see a lot of RFEs, and the timeline was extremely bad. I mean, 6 months used to be the normal, and 6 to 1 year used to be what we used to see for regular filings. And I'm talking about pre-2020, pre-2021 timelines. And the reason for that was the adjudication standards are also very different. So back then we used to have different rules, and we used to have something called employer-employee relationship. We used to have requirement of client letter, requirements for contracts, requirement for vendor letters, and we used to have different kinds of requirements back then. And we also used to have approvals for short durations. We used to see approvals for 1 month, sometimes 1 day, and many times approvals are not for 3 years. And I'm talking about pre-2020 time period. And then COVID hit, and not only COVID, what also happened was USCIS made some major rule changes with H-1B adjudications. They rescinded a couple of prior USCIS memos. So they had a memo in 2010, it's called the Newfield memo, and then they had a memo in 2018 where they kind of mandated some requirements to prove employer-employee relationship to, and they also required contracts. And in 2020, what happened is they came with a memo. This was in 2020 June time period. They came with a memo and said they're rescinding the old memo. So the 2010 Newfield memo and the 2018 memo that talked about the contracts, itineraries, client letters, employer-employee relationship, it got changed. And now what happened is USCIS totally simplified the process. And they also said that approvals will be given for 3 years, not for anything less than 3 years. And if they give it for less than 3 years, in writing, they will explain why they're giving it for less than 3 years. And after that, what has happened is overall, the process became a lot smoother and a lot faster because USCIS was focusing on different issues when they give RFEs and not really focusing on things like client letters, contracts, duration of contract, etc. So that's when things actually started getting better. But in the recent, I would say last, especially 2024 and probably also 2023, USCIS also invested heavily in upgrading their computer systems. And what that means is the way they do their background checks, the way do a lot of background processing, they improved it. So they can quickly do, their systems are very, very powerful. I mean, we have seen some RFPs where they bring data from so many sources. So it is not that easy to commit fraud. USCIS has very, very good ways of detecting fraud. Because their systems, they have upgraded their systems and it is easier to detect fraud. What that has happened is nowadays they can process cases a lot more quicker because the goal of USCIS is to ensure that H-1B petitions are adjudicated timely, but not at the cost of the security of the country. So they do have a burden of ensuring that proper background checks are done, proper analysis is done, there is no fraud. So that is a part of their job. And now with their computer systems kind of doing things a lot more quickly, the background checks, they're able to do things a lot more efficiently. And that is actually showing results. So in 2024, we are seeing numerous cases where we are seeing approvals in less than a month. And I'm talking about regular cases, not premium processing cases. So, so whatever money they've invested in computer systems, that is clearly, I think, producing results. And not only that, this year, starting from April, we are also having the entire H-1B filing possible through e-filing. So we don't really have to send a paper copy to USCIS. It's simple. You do an online filing. It not only helps the petitioners, the attorneys who are doing the filings, but it also helps USCIS because they don't have to get a paper copy. They don't have to scan it back into their system, waste all the time working with a paper copy. So all the inefficiencies are being removed. And clearly, I think that has helped in smoothening the process, seeing very, very speedy approvals. I mean, 1 to 3 months is what most of the cases are taking nowadays. Even though some cases we do see delays, it's probably because that particular case is different. It requires some additional background check. But overall, I think we are very happy with what we are seeing. And I think even the petitioners, they're very happy. Not only that, USCIS has also increased fees drastically since this April. And I think they're using this money to fund their computer systems. So the fee has increased, but definitely I think they're at least helping in doing speedy processing. We expect to continue to see this speedy processing in the next couple of months.
Absolutely, me too. And going digital, they're not only saving papers, but also doing good to the environment as well. So saving trees at the same time. So yes, going
Right.
green. Thank you so much, Chan, for the detailed explanation. And looks like it's a win-win situation for many this 2024 at least. Moving on, Chan, I have another question. And this time, what steps can employers and applicants take to mitigate H-1B adjudication delays?
Sure. So definitely there are a lot of things that both the employer, who is the petitioner, as well as the applicant, together can do to ensure at least their file from a practical perspective take the shortest possible time. And the first and the foremost thing on a high level is submit complete and accurate application. And what that means is the petitioner should be prepared to produce everything upfront, and even the employee should be prepared to produce everything upfront. We have many cases, for example, at the time of cap filing, we have cases where the employee has the mark sheets. Sometimes they don't have the diploma copy, or sometimes they have the diploma copy, they don't have the mark sheets, or they just have an unofficial copy. And sometimes we have some cases where the applicant, the beneficiary, they just realize that their passport is expired. At all times, a person is supposed to have a valid passport if they're in US, but sometimes they just realize their passport is expired and they have a deadline to file. So things like your passport, your educational documents. So these are some things that we want to make sure that they give on the day of filing. And what that means is people should not take any chances. We had number of cases where they come back and say we are not able to find our diploma copy. We only have the mark sheet. Go ahead because there is a deadline. We'll think about it later on. Things like that are what would delay the application. And on the employer side, uh, a lot of times they give a very hurried preparation of the job duties. They give a very short description and they say, hey, this is what it is. Go ahead with it. The job description is not detailed. We have seen so many RFEs delays the process. So probably the employer, the petitioner, they should take some time and write as detailed job description as possible. H1B is applied for 3 years, so we are asking for an approval for 3 years. So employer cannot just give like a paragraph or 3 or 4 lines and say that is what the employee will do for the next 3 years. It has to be as detailed and as elaborate as possible. So the job description, it should clearly include day-to-day job duties. It should include the percentages. The more detailed job description you have, the more lesser the chances of USCIS coming back and saying this position is not complex or this position is not detailed enough. So things like that. And uh, offer letters. So make sure the offer letter has the right salary. We had some cases where employer accidentally puts the wrong salary. USCIS comes back and says your offer letter, you're offering less salary. So be as complete, as accurate as possible. Try to make sure all the documents are there. In any evaluations, a lot of times employers, they don't want to spend money on evaluations, which is understandable. A lot of cases do get approved without evaluations. But again, if you want to kind of eliminate any kind of slowness by getting an RFE for educational evaluation or work experience evaluation, sometimes it is better to be proactive and get evaluations done upfront. And again, some petitioners do want to take a chance, but uh, from our perspective, the recommendation is if your application is complete, as thorough as possible, um, you'll see less surprises. That being said, again, there is always this timeline because timelines are very important for immigration. Sometimes somebody's status is expiring or somebody needs to do a transfer and their 60-day grace period is expiring. So we do see some cases where in the interest of time, sometimes even the recommended things like evaluations are not added. But again, if you want to kind of reduce any uncertainty, be as thorough as possible. And next thing is the RFEs. When somebody gets an RFE, it will slow down the process. And when somebody gets an RFE, we have 90 days to respond back to the RFE. And what that means is once we get an RFE, the employer sees the RFE, it is very important. Employer starts preparing and getting the documents out as quickly as possible. So what we say is, yes, you do have 90 days, but the sooner you get the documents all ready, the sooner you can respond back and quickly get an adjudication and a positive approval and get it out of the way. So another thing is speedily responding back to RFEs. And then premium processing. So premium processing is available. However, it is very, very expensive. It is $2,805. So if somebody wants to use premium processing and expedite their case, you can do it, but it is a $2,805 additional expense. But again, there are times when there is no choice because either somebody is hitting a 240-day deadline for an H1B extension or somebody has like a cap gap deadline. So if you are getting into one of those scenarios, definitely use premium processing because premium processing They guarantee to do it in 15 business days. So if it is a case where you don't have a choice, definitely use premium processing to speed up your cases. And then we also talk about site visits, and FDNS visits. These are common for any company that relies on H1Bs. And what we suggest is anytime a company has a USCIS site visit, these are voluntary. You don't really have to participate in it, but we strongly recommend companies to participate and help the USCIS officer, provide them the information, prove that you're complying with the terms of the H1B petition. Because the sooner you respond to site visits, the sooner you cooperate with the USCIS officers, it will help your future petitions. It will help your future petitions. It will ensure that it gets reported back to USCIS that your company has cleared the site visit, everything looks good. So even we hear some petitioners come back to us and say, hey, it is a voluntary site visit, I don't have to comply, I will not answer the site visit. Legally, yes, that is true. I mean, nobody can force you to answer a USCIS FDNS site visit, and even if you don't do it, USCIS cannot deny the case. But you'll probably have a red flag, and that'll cause increased scrutiny, and every case of yours is going to get scrutinized. So what we suggest is we strongly recommend, if anybody has a site visit, prove to the USCIS officer, cooperate with them, and prove that your H1B petition is in full compliance. You're paying the employee like you're supposed to do. You are uh, getting things done. Employees working from the location that he or she is supposed to work, and so on. So doing so, I think, will clear up your company, and it will reduce the likelihood of processing delays, and it will ensure smoother H1B adjudication for all your future cases.
Absolutely. So keep in mind, friends, it's very important to cooperate and see that your case runs smoothly and is done as fast as possible without any objections or obstacles coming in between. So let's go for it. All the best. And Chance, thank you again for taking that question up and for the detailed explanation. I have another question, and that is if you can tell us how is the State Department's green card quota affecting H1B adjudications this fiscal year?
Sure. So, in general, H1B is a separate, independent process. The green card filings are independent things that are happening. Both are different. However, the main thing is the H1Bs, they can be only be given for 6 years. So, if you want the H1B to be extended for more than 6 years, a person should have an I-140 approved, or the perm should be pending for more than a year. So there is this little bit of dependency on the green card process. So when I talk about the green card process, we're talking about the perm, which is a DOL filing, and we're talking about I-140, which is a USCIS filing. And lately, what we are seeing is we are seeing delays on the perm side. We are seeing delays on the prevailing wage side. So whenever the perm processing gets delayed, I-140 processing will also get delayed because you can't really file the I-140 till the perm is approved. So if anybody is finishing up their 6 years on H1B, those adjudications will be impacted if the perm or I-140 is not done yet. That is a big factor. That being said, the Department of State side. So the Department of State, which looks into the green card quota, making the dates. I mean, who's in charge of the visa bulletin? So those dates, the way it will impact H1B adjudication is if the dates are current. Normally, the 485 has to be filed, and if 485 is not filed within 1 year, H1B cannot be filed. So from a H1B adjudication perspective, if somebody's dates are current and somebody has an I-140 approved, USCIS expects the 485 to be filed within 1 year of the dates getting current. If not, H1B adjudication will be impacted. So that is one place where we see a problem with H1Bs. But if the dates are not current, there is nothing to be done. All you can do is keep applying for H1B extensions, keep submitting proof of your I-140 approval or perm being in process for more than a year, and H1B will need to be extended. And in general, this process of H1B adjudication is independent of State Department's green card quota. And last year, the green card quota, the dates have not really progressed well ahead for India. the dates are stuck in 2012. So whoever has entered this green card processing in 2012, those are the folks that are getting green cards right now. So anybody after 2012, right now the dates are not current. So pretty much the only alternative is keep on extending your H1B. Make sure you fully comply with H1B process and wait until your dates are current.
Patience is virtue, friends, and doing the right thing at the right time and making sure that all your documents are correct. I think these are the things you have to keep in mind and be as detailed and as thorough as possible. All the best. Thank you so much, Chand, for the detailed explanation once again. And I have another question now. We'll go quickly into it. What recent trends in H1B qualifications are influencing application approvals?
So the main focus that we see for H1Bs is specialized roles, and what that means is I think USCIS is focusing more on the STEM fields because when you talk about specialty occupation, specialized roles, uh, this requirement has to be met before USCIS can approve a H1B. And we see more emphasis on the STEM roles, so science, technology, engineering, and mathematics, the STEM fields. So the STEM fields are theoretically specialized positions, and USCIS is scrutinizing every H1B petition to ensure that they meet the criteria for specialty occupation. So that is very important. So normally, what that means is they're making sure the positions are in these fields, STEM, and uh, more importantly, it has to be a specialized field because there could be some fields outside STEM, but as long as it is specialized, it meets the definition of specialty occupation, they will give the H1B. So they are focusing on that specialized part. And the next part is also the increased wage requirement. USCIS always they have to make sure that H1B workers are paid wages that either meet or exceed the prevailing wages for their position and location. And what that means is LCA requirement. So they are heavily focused on the LCA. They are focused on the wage levels. They are also focused on the kind of occupation. So they're looking at something called the ONET codes, ONET occupations, and they are very closely monitoring the LCAs. They're looking at what the LCA says. They're also looking at what the petitioner says that the employee will do, the job duties. Make sure everything is aligned. Uh, make sure that H1B worker is not going to depress the wages for US workers. So that is a part of the job. So looking at LCA, looking at the certified LCA, making sure the job duties align with that LCA is a big part of their adjudication, and that is very important before the case can get adjudicated. The next major focus is on educational requirement. They are heavily focusing on the educational requirements. So what they do is they look at the position, they look at what is the industry standard for that position, and then they see what is that the applicant has, the H1B beneficiary has. And if there is a mismatch, for example, it's a software developer position, as per the industry standards, we require an IT degree or a computer science degree or something close to the field of computers. And say the employee has a mechanical engineering degree. So they are closely looking at educational requirement. And the trend is that if the candidate, the beneficiary, does not have that particular educational requirement, they're going to cause an issue. They're going to issue an RFE and cause an issue. So educational requirement is a big focus. Beneficiary qualifications RFE is probably the biggest RFE uh, that I think that's showing up on the H1B side. And next thing is the detailed job description. There is definitely a heightened focus on the job descriptions, and the USCIS officer, they are clearly looking at the detailed job description because the officer has to be convinced that the job really requires specialized knowledge, and the only way they can figure that out is if they have a detailed job description. So the petitions must clearly demonstrate that the job duties are complex enough. If they're not complex enough, you cannot justify a H1B visa. So there is definitely a focus on that part. And I think finally, I think they're looking at employer-employee relationship and things surrounding it. However, USCIS has made it a lot easy. Now they have a very easy way of seeing if that burden is met. Employer-employee relationship has to be met, but that is pretty easy. And what that means is if employer is able to demonstrate either the right to hire, fire, pay, supervise, etc., they can prove the employer-employee relationship. And the way you can prove it is the fact that employer is attesting to the LCA, the fact that employer is giving an offer letter, employer is bound to pay that salary to the employee, will help easily prove employer-employee relationship. In the past, we had to go through client letters, vendor letters, and a whole bunch of other things to prove that employer-employee relationship. Nowadays, it's pretty easy, but USCIS is definitely focusing on making sure every H-1B petition satisfies the burden of proof for employer-employee relationship. And so these trends, in summary, what it means is that the H-1B beneficiaries and the employers need to be aware of these things, need to provide well detailed, well documented information concerning the job duties, concerning the beneficiary qualifications, prove that they're complying with the rules, and just keep up with the evolving standards, and that will improve the chances of approval.
Absolutely. I hope you took those notes, friends, and keep those things in mind and do what is required. All the best. Thank you once again, Chand, for the detailed explanation. Now, if you could tell us, are there any specific challenges or delays in H1B adjudications for OPT and CPT holders transitioning to H1B?
Sometimes we do see some additional challenges for anybody that is on OPT or CPT. Normally, so if somebody is on CPT, curricular practical training, we tend to see more RFEs. So CPT basically means that somebody is still in the school, in their college program, university program, and while they're going to college, university, they're also simultaneously participating in employment. So they're working for a company, they're also attending school on F1 status. And CPT program sometimes tend to be misused. So because of these reasons, anytime we see somebody is on CPT and they're applying to H1B, USCIS tends to issue RFEs, and the goal of these RFEs for CPT folks especially is to prove that they're actually attending college and they're actually doing everything they're supposed to do for their the F1 program, and also show a justification on why they need to work while they're actually studying. So there is a process, and they just want to make sure that nobody's misusing the CPT program to work outside the university. So it is not a tough RFE, but it is a little bit of a cumbersome RFE. And we have seen these RFEs delay the process because not only USCIS is waiting for a response back, but because these responses are so cumbersome, they also take some time to review the entire documentation before they give an approval. And when it comes to OPT employees, so OPT RFEs do come occasionally. I mean, again, it is not as common as CPT, but OPT RFEs do come. And normally, to reduce OPT RFEs, what we suggest is at the time of filing, prove that you're working, prove your employment through pay stubs, etc. And if USCIS sometimes they suspect that the OPT student is not properly employed, and the way they know that is sometimes not just through the H1B filing. Sometimes they also look at the service portal. The service portal will have information about the student's employment, student's address history, and so on. So if they find some discrepancy in their OPT students' service record, they tend to issue this OPT RFE. And OPT RFEs, the main challenge with OPT RFE is that if somebody is on cap gap, the OPT employee will only have authorization until September 30th. And after September 30th, if somebody is on cap gap, they might not even be allowed to work. So what that means is they really have to answer the RFE quickly and get an approval, or more than likely might have to upgrade the case. So OPTs and STEM OPTs, we do see these challenges of getting these RFEs. And the goal of USCIS is just to ensure that OPT or CPT, they're on F1 status. They just want to make sure that all the rules of F1 are complied by the students, and they're not having any unemployment if they're on OPT. And if they're on CPT, that CPT employment is actually required for that program, and the F1 student is actually attending classes, and so on. So the summary is that they don't want anybody to misuse either CPT or misuse OPT. And because of these reasons, sometimes people can get an RFE, but if you're well prepared and you're doing everything you're supposed to do in the F1 program, we normally don't see challenges in getting an approval unless somebody has really done something to not comply with the F1 regulations.
Right. Thank you so much, Chand, for the detailed explanation. It was really nice of you to give us a thorough walkthrough to this, this challenges, especially the delays in H-1B adjudications for OPT and CPT both, and transitioning to H-1B. Thank you, Chand. Now, how does this increased demand for H-1B visas impact approval chances in 2024?
So in 2024, I mean, definitely, I think we are seeing increased demand. And again, USCIS has given the statistics in terms of the number of applications they got for H-1B lottery. The number was a lot less than last year in terms of the numbers. But again, that was more because last year we had this huge multiple registration problem. This year, luckily, USCIS solved the issue of multiple registration. So this year we did not have the multiple registration problem. But when we look at the number of the registration filings, the H1B lottery, the H1B, the entire registration system, it was oversubscribed multiple times. We only have 85,000 annual H1B, new H1B visas. And the number of registrations submitted was more than four times what was available. It was more than 400,000 registrations. So what that means is USCIS understands that H1B is very competitive. They also understand that H1B program is very important for US economy. And what that means is they do have a burden of ensuring that people don't misuse either the H1B lottery, the H1B system, or the H1B program as a whole. And USCIS clearly they introduced some reforms this year. They talked about solving the issue with multiple registrations. Starting from next year, they also talked about increasing the fee for H1B registration. And not only that, they are also increasing their scrutiny. And wherever they suspect that the company is not bona fide or the company is not legitimate, they issue RFEs. So overall, I think the increased demand also means that USCIS has to be more responsible, ensure that people are not defrauding the system, ensure that USCIS is is the face of the government, where they ensure that uh, the sanctity of the system, the sanctity of the H1B program is maintained. So we definitely, I think, more demand means USCIS sometimes could issue more requests for evidences if they ever feel that somebody is misusing the system, or sometimes somebody might not be misusing the system, but somebody might just apply for a H1B and maybe that job is not a specialty occupation job. So USCIS wants to ensure only the best and the brightest are using the system, because it is a very highly competitive program where there is a quota limit. So if USCIS is approving cases for the positions that are not qualified for specialty occupation, then it is hurting US because uh, now, because of this limited quota, limited 85,000 quota, somebody with uh, real value addition is losing a chance. So they want to make sure that everybody is complying not only with the goals of H1B program, but also with the labor standards, because this H1B program sometimes could cause a depression in wages in US if it is not done right. And what this means is USCIS is continuously scrutinizing the applications, and sometimes that means further delays to ensure that the sanctity of the H1B program is maintained and people don't misuse the system. And also the economic and policy pressures. When I say policy pressures, we have elections this year. Come November, we're going to have presidential elections. We're going to have a new president. And whenever you have a new president, the expectations on the president are very high, whether it is President Trump or President Kamala Harris. The expectations are very high. The people expect them to do a good job to make sure it is this H1B program is not depressing the wages on the US side, and it is only used for that purpose that it was designed. So both the presidential candidates, they do agree that highly qualified workers have to be let into the country. They do contribute to the US economy. But because whenever we have a new president, there will be policy changes. And the goal of the policy changes is to ensure full compliance, to make this process even better. So sometimes that could mean delays in the process, but definitely we can expect some policy changes getting into the presidential elections. And also the economic pressures. When the economy is bad, more people lose jobs. More people in US lose jobs. And what that means is again, USCIS also has a pressure to ensure only the best and brightest are using this program. So these kind of economic pressures, policy pressures, again, some companies misusing this H1B program, all of this will sometimes, uh, uh, interact with increased demand because you only want to use the system for the best and the brightest. So definitely, we could anticipate more delays if there is a lot of demand. Not only a lot of demand, but if USCIS, as they do the data analysis, if they feel that somebody is misusing the system, they will always revisit their policies. So the bottom line is, if less people uh, apply, definitely always it means things are a little bit smoother. More people applying means more pressure on USCIS. So could adjudication standards could get delayed. Sometimes you might see more time for USCIS to approve a petition. But hopefully, I think we're just hoping that things are smooth. Only the genuine and legitimate companies use this program. So that way, it's easy for everybody who's using this program um, to get a speedy approval. And hopefully, things are smooth getting into this election year. And hopefully, not many things change next year. But again, all indications are that some things could change once we have a new president in office. And USCIS also had some drafts for policy changes last year. So last year, they published some policy changes in the Federal Registrar. They have not finalized those rules, but things could change. If policy changes, again, we have to come back and have another discussion. And I do think some things could definitely change in 2025.
Very well said, Chand. And also, like, we have our new fiscal year starting October. So, any notes on that you want to share as well?
Sure. So the fiscal year starts October 1st. So the 2025 year for immigration, it starts on October 1st. So anytime we talk about 2025 H1Bs, it's starting from October 1st. And in terms of the 2025 fiscal year's H1B adjudications, I think uh, we are just hoping not many drastic changes happen with USCIS, but looking at what they have published in the Federal Registrar last year, drastic things could happen next year because they're talking about changing the definition of specialty occupation. They're talking about the bona fide job offer definition being refined. So if these things are changed and USCIS comes back with more information in the future, they publish it in the Federal Registrar and say this is the final rule. It could definitely impact, and I think at least a few things will definitely change in 2025. One thing we know for certain that is changing is the fee for the H1B lottery. So the fee for the H1B lottery is drastically increasing from this 2025 fiscal year. So starting March, uh, people can expect to pay a lot in the H1B registration fees. It was $10 last year. It's going to be over $200 this coming March. So at least that is one change we know is definitely happening, and we can expect to see a few more things probably published in the Federal Registrar in the next coming months, probably next year.
All right, Chand, we will look forward for all these changes, and hopefully, all are going to be super beneficial to everyone out there. Thank you, Chand, for the detailed explanations once again. And moving on now, I have one more question. It'll be the last for me. And if you could tell us now, what updates have been made to the H1B cap process, and how do these changes affect applicants?
So, in terms of changes to the H1B cap process this year, the main changes that have happened are to do with the multiple registration. USCIS came back in January, end of January, and they said the cap process is going to change this year. The main changes this year, instead of taking a random lottery, what they're going to do is they're going to take a lottery based on the passport numbers of the beneficiaries. So every beneficiary will have only one chance in the lottery, and that is through their passport number. So last year it was a little bit different. If they had multiple job offers, so they were able to participate in the lottery that number of times. I mean, it increased their chances because each time a petitioner put them in the lottery, they were getting an extra chance. So that was the big change that started off this year when it comes to the cap process. And the change is no more benefit with multiple companies sponsoring somebody's H1. Everybody's treated the same. Everybody gets put in the lottery in the same manner. And the passport number, which is the unique number for anybody, that is used to select somebody in the lottery. So that was a very major change, and I think everybody, attorneys, petitioners, employees, everybody welcomed that change because we have seen what kind of a mess happened in the last couple of years with multiple registration. That was a very very major change. And the second major change is the fees, the H1B fees. H1B fees increased drastically this year. So for the cap filings, if you look at the cap filings last year versus the cap filings this year, the fees drastically went up. And for the small companies, luckily it was only $300. But for any companies that are not small companies, and USCIS's definition of small company is a company with less than 25 employees. So a company with less than 25 employees has to pay $300 additional to what they paid last year. But any other company that has more than 25 employees, they are paying almost $920 additional to what they paid last year. So that's a big substantial increase compared to last year.
Very
So
big.
again, that was one major change. And then finally, the second lottery. For when we talk about cap, this year again we have the second lottery. And in terms of the numbers that were selected in the second lottery, it was not very high compared to last year versus this cap. Last year, almost 80,000 registrations were selected in the second lottery. This year, it was a very,
Yes.
very small number, less than 20,000 number. So it was a small lottery, which is why we tend to, I mean, I'm of the feeling that we more than likely will not have a third lottery because very few people got selected in the second lottery. We never know.
True.
But again, that's another thing compared to last year, what happened last year cap versus this year's cap. Again, in terms of adjudications, things are exactly same as last year. There is no additional burden of proof to prove on the H1B petitions. Whatever standards were there last year, they're following the same standards, except that again this year we have e-filing. So we did have a lot of cases during cap filed in e-filing. So in our law firm, we use a mix of both the paper filings and e-filings. So we have some cases e-filed, some cases paper filed. And in terms of adjudication delays or timelines, we are seeing both of them being processed pretty efficiently. We're not seeing anything major differences between paper or e-filing, except that the e-filing website sometimes is not working like it should. But in terms of adjudications, both seem to be pretty efficient this year.
Yes, very well said, Chand, and thank you so much again for the detailed explanation. Today, we covered what's happening with H1B adjudications in 2024. I mean, everything from challenges to RFEs, OPT, CPT, and how to go about transitioning to H1B. So it was really lovely. Chand, if you could also, give us an end note to this topic to wrap up this session, it would be great.
Sure. So, so to wrap up today's show, I think the good news for everybody is USCIS is becoming faster and faster in their H1B adjudication. And what that means is you don't really have to spend a lot of money on premium processing. Premium processing is very expensive. So you don't really have to spend money on premium processing. And sometimes be a little bit patient. You might not see an approval in a month, but things are faster. So definitely my suggestion is don't upgrade a case on day one. Don't file a case in premium on day one unless you really have a very good solid reason. If not, things are smooth. And another big thing is, as a whole, if there is less fraud, it'll help the industry as a whole. It'll help USCIS as a whole. So less fraud means cases will get approved more quickly. And what that means is we just hope that companies are not exploiting the H1B program. Companies are not trying to commit fraud. The less we have of that nuisance, the more faster USCIS will be able to speedily adjudicate petitions. And when I talk about fraud, we hear about companies taking money from H1B beneficiaries, taking money and filing, and all those kinds of things. So all these things are fraud that not only impacts that company, it impacts the industry as a whole. Because if one person commits fraud, USCIS has the burden to scrutinize everybody's case because they want to make sure that people don't misuse the system. So overall, the summary is, if we discourage people who are trying to commit fraud, it'll help the entire industry. It'll help every petitioner that is legitimately trying to do business, legitimately trying to get things done. And it'll also help people, the beneficiaries who are highly qualified. It'll help them get a speedy adjudication when things are smooth. And we encourage everybody to strictly follow the rules and not take any shortcuts in this H1B process.
Very well put in a nutshell, Chan. Thank you so much for telling us, for this H1B adjudications in 2024, for walking us through everything today. It was really lovely having you explain everything in details. And yes, thank you everyone for joining us today on this
Yeah, thank you,
engaging
Nipasa.
episode of. Yes, thank you so much. Thank you definitely, for this very engaging episode on immigration and jobs talk show. And I truly hope that everybody out there found the insights shared by our expert attorney Chance Parvataneni very valuable as we navigated the complexities of H1B adjudications in 2024. So feel free to contact attorney Chance Parvataneni. We have his details also. So you can note down his phone number. You can call him on this number 732-979. Sorry. Once again, I repeat 817-523-8247. That is Attorney Chant Parvataneni. You can also email him law@spblawfirm.com, and definitely go visit spblawfirm.com to get to know more about Attorney Chant Parvataneni and SPB Law Firm. Thank you, Chand, once again. It was lovely having you here today.
Thank you, Nipasa.
Have a great day. And friends, feel free to drop your questions in the comments because we are going to have our experts to answer them for you. So thank you so much for joining us. And it was lovely having you all watch us here on YouTube, LinkedIn, and Facebook. Thank you so much once again. Well, until next time, then, take care, stay informed. And this is Nipasa Pradhan signing off from Immigration and Jobs Talk Show.